Welcome to the second session. In this particular session, we are covering two important aspects. The dilemma of implementing Section 15, preliminary assessment for children in conflict with law. And the second component relates to psychological and mental health consideration in assessment and expert assessment child psychologist. The role which the child psychologist has to play in that regard. The session is being shared by two, Madam MANDEEP PANNU. She joined the Punjab Judicial Service in the year 1994. She was promoted to the Superior Judicial Service in the year 2008. She was with us in the Chandigarh Judicial Academy faculty from the years 2015 to 2018. Presently, she is District and Session Judge Moga. Even when she was on the faculty here with us, particularly in the programs relating to juvenile justice, she played a very active, keen role in dealing with different aspects. And therefore, she brings in rich experience in this particular domain. The second resource person is Madam AARZU GUPTA, the child psychologist. She is Assistant Professor, Clinical Psychology in the Department of Psychiatry, Government Medical College and Hospital, Sector 32, Chandigarh. Clinical profile of children in conflict with law is an important aspect which she would be covering as such. And therefore, both the resource persons would take this particular session, make the best use of it. Thank you so much. Over to Madam Pannu.
Good morning, everyone. Thank you, sir, for giving me this opportunity of sharing my views with the judicial officers and other stakeholders. The session is preliminary assessment for children in conflict with law. As we all know that after Nirbhaya's case, where one of the offenders was just 3 months short of 18 years, which was the maximum punishment at that time provided under Juvenile Justice Act 2000, he was released after 3 years. So emphasis was laid on increasing the quantum of punishment. So accordingly, the concept of preliminary assessment was introduced in the Juvenile Justice Act 2015, as per which CCL aged between 16 to 18 years alleged to have committed heinous offence can be tried as an adult after conducting preliminary assessment, and if found guilty can be awarded punishment for more than 3 years. So before we come to this concept, we study this concept in detail, I would like to take you to the procedure which is to be followed by JJB before conducting preliminary assessment and after conducting preliminary assessment, and the procedure to be followed by the children court after conducting preliminary assessment. So we'll talk about CCL aged between the age group of 16 to 18 years who are alleged to have committed the heinous offence. So the first step is the registration of the FIR, followed by apprehension of the child alleged to be in conflict with law. And if he is apprehended by the ordinary police, his custody is to be handed over to the CWPO. So that CWPO, he can prepare the social background report immediately. And side by side, it is the duty of the CWPO to inform the probation officer so that he can prepare social investigation report, which is to be produced before JJB within 2 weeks of the first production of the child before the board. Then comes the stage of bail that is to be decided by the police. Now, if he is released on bail, then he is to then his parent or the child or the guardian is required to furnish give the undertaking before the police. But if he is not released on bail, then he is to be produced before the board within 24 hours of the apprehending the child. Now, on production of the child before the board, it is the duty of the CWPO to produce social background report, circumstances of apprehending the child, and offence alleged to have committed by the child. Then comes the stage of bail to be decided by the board. After taking the decision on the bail or by the board, then comes the stage of presentation of the final report. This final report in such like cases is to be presented within 1 month from the first production of the child. And final report consists of statements of the witnesses recorded by CWPO and other documents prepared during investigation. Then it is mandatory for the Juvenile Justice Board to supply copy of all these documents to the child or the parent or the guardian of the child. So in nutshell, we can say that before conducting preliminary assessment, before taking this exercise, JJB has social background report, social investigation report, and the final report. Then comes the stage of preliminary assessment, which we will discuss later on. We'll first see what is the procedure to be adopted by the JJB after conducting preliminary assessment. Now, after conducting preliminary assessment, JJB has got two options, either to order the CCL to be tried as a child or as an adult. Where he is to be tried as a child, then the inquiry is to be conducted by the board itself by following the procedure for trial in summons cases. But where he is to be tried as an adult, then the trial is to be transferred to the children court as required under section 18 subsection 3. Now the trial is before the CC after receiving the same by way of transfer. Now CC is to decide again. Now this means CC, it is mandatory for the children court to conduct preliminary assessment. Now, after conducting preliminary assessment, again CC has got two options, either to try the CCL as an adult or as a child. But in both the eventualities, the trial is to be conducted by the children court itself. The only difference is that while trying the CCL as a child, the inquiry is to be conducted as a board and the procedure of summons case is to be followed. Whereas while the CCL is going to be tried as an adult, then the CC is to follow the procedure of trial by sessions. And the difference is also regarding the in the quantum of punishment, because when he's being tried as a child and found guilty, then CC children court is to pass the order as provided under section 18. Whereas when he's tried as an adult, then any imprisonment can be awarded, but except for we can say death sentence or life imprisonment without the possibility of release. So this was the procedure to be followed before conducting preliminary assessment and after conducting preliminary assessment. Now we come to the concept of this innovative concept of preliminary assessment. The theory part has already been discussed by Mr. Sarah in detail. So I would come to the practical part, that how the preliminary assessment is conducted. So this preliminary assessment, the board is to be conducted with regard to three aspects by the board as well as CC. Now, what are these three parameters? The first parameter is the mental and physical capacity of the child to commit such offense. And the second, his ability to understand the consequences. Third, the circumstances in which he allegedly committed the offense. Now, so far as parameter A and B are concerned, both these parameters are interrelated because the ability to understand the consequences would be there where the CCL has the mental and physical capacity of the child to commit such offense. So these two parameters, we will discuss these two parameters later on with the assistance of child specialist Ms. AARZU Gupta is already with us. So first we will discuss a third parameter, which is circumstances in which he allegedly committed the offense. Now the question is how to appreciate the circumstances or how to draw an inference from the circumstances of the case that there is a need for trial of CCL as an adult or child. So for this, I will take you to the case laws on various honorable high courts. Because this third parameter can be understood with the help of the case laws only, because in these cases honorable high courts have discussed how to appreciate the circumstances, how from the circumstances of the case, how to make out this third parameter. So the first case which I'm going to discuss is Srimati Durga versus State of Rajasthan, 2019, Criminal Law Journal 2720. The facts of this case were female CCL who was married to deceased for the last 3 years. She was 14 years old at the time of marriage and 17 years old at the time of occurrence. So both CCL and the victim husband, they were not keeping on good terms and they used to fight on trivial issues. Deceased used to beat her every other day after consuming liquor. On the fateful night, she was again badly thrashed. She became infuriated and gave him a single blow with an axe which proved fatal. Now the matter was before the JJB and report of the medical expert was called, and in the medical report or in the report of the psychologist, we can say it was mentioned that CCL was found to be cooperative and communicative. She was aware of the act done by her and about the consequences. And according to her, she was having conflict with her husband for the last 3 years, off and on the day of crime, they were both fighting physically and verbally. In the social investigation report, it was mentioned that child was feigning mental impairment after killing her husband. So JJB formed the opinion that CCL was clever enough to understand the consequences. So that is why she was pretending mental impairment after killing her husband. So JJB observed that as per social investigating report, since child was feigning mental impairment, whereas medical report indicated that she was physically and medically able person, so she can be treated as an adult. So accordingly, she was ordered to be treated as an adult. Now the matter was before honorable. Even the appellate court also upheld the version of the JJB. Now the matter was before the Honorable High Court. Now, Honorable High Court held that as per the material available on the record, CCL, who was married at the tender age of 14 years to the deceased for the last 3 years, was facing marital strife on a continued basis, and thus she was a child in difficult circumstances. On fateful night also, she was again badly thrashed, and thus she became infuriated. And in these difficult circumstances, she gave a single blow with an axe to her husband, which proved fatal. So it was observed that she cannot be attributed with the mental ability because she committed the offense on the spur of the moment after being traumatized by the cruel behavior of the spouse. So she was ordered to be treated as an adult under Section 15 of the JJ Act. So Honorable High Court further observed that while directing the trial of child as an adult, the board must remain alive to the situation that the offense has been committed by the child in such a manner which gives rise to an inference that the act was done in a cold-blooded or calculated manner, and whether the child was driven to commit the offense because of the conduct of the child. Like we have seen in Durga's case, it was not a cold-blooded murder, it was not in a calculated manner, but the child was driven to commit this offense because the conduct of the victim was such. He, in an inebriated condition, thrashed her, and he daily used to thrash her, and on the fateful night also he was in an inebriated condition and thrashed her. So it was this provoked the victim to the CCL to commit the offense. So that is why Honorable High Court ordered that she should be treated as a child and not as an adult. Now we have another case, Ajay versus State of Maharashtra and another. In this case, the CCL was ordered to be tried as an adult. Why? Because the facts of the case were that CCL called the victim girl, aged 7 years, inside his house and committed rape on her. Now, JJB held that as per the SIR report, CCL had completed 11th standard. He was not interested in learning. He was working in a company. CCL himself explained the act done by him to the probation officer. He took advantage of the situation that nobody was present in the house. He committed the alleged act knowingly and after taking care that nobody would know the same. So in these circumstances, he was ordered to be treated as an adult, and this order was upheld by the Honorable High Court also. So we have another case, Mumtaz Ahmad Nasir Khan versus State of Maharashtra. It's a very lengthy judgment, so I'm not going to read out the facts of the case. In short, a murder was committed by the CCL of a 3.5-year child, and medical report and the social investigation report. Both these reports suggested that he committed in an adult state of mind. He committed the offense in an adult state of mind. So JJB, without appreciating the circumstances of the case from the facts, after referring to the social investigation report and the medical health report, observed that in the circumstances stated above, I do not find any mitigating circumstances to extend the benefit of JJ Act to the CCL. So the CCL was ordered to be treated as an adult. Appellate court also upheld the order of the JJB. Now the matter was before Honorable High Court. Honorable High Court held that JJB has undertaken no independent assessment because the facts of the case were not appreciated. In the observation home, the conduct of CCL is reported as good. He pursued his studies. Both SIR and medical health report and the report of the expert revealed that he has been remorseful after the event. The Honorable High Court observed that board has mechanically relied upon SIR and MH report without analyzing the case of CCL on its own. So in nutshell, we can say that while appreciating this third aspect, while undertaking the exercise of preliminary assessment, JJB must adhere to the circumstances in which the offense took place. And for this, the medical report or the report of the expert is not very material. The circumstances have to be considered independently without taking assistance of the expert. And while considering these circumstances, JJB has to apply a judicial mind. So this was regarding the third aspect. And as I have told you that we will discuss first in two aspects later on with the assistance of, after taking the views of the psychologist, Ms. AARZU Gupta. So first, I have been given 10 queries by the JJBs and Children Court. I would like to answer those queries with the help of the case laws and the provisions of the JJ Act. The first query is whether JJB, while conducting preliminary assessment, is bound by the expert opinion. So we have a case law on this. Pradeep Kumar versus State NCT of Delhi, 2019, DLT, page 641. So in this case, it was held by Honorable Delhi High Court that no doubt JJB may seek the opinion of an expert regarding the mental and physical capacity of the CCL, but it is not necessary that if the opinion of the expert is positive, then the JJB is bound by the expert opinion. So meaning thereby JJB can agree or disagree with the report of the medical expert or the psychologist. So second query is whether habitual offender can be given benefit of juvenility. So in this case, what happened? There were certain FIRs registered against the juvenile. So at the it was contended on behalf of prosecution that since FIRs have been registered against the juvenile, so he should be treated as he's an habitual offender and he should be treated as an adult and not as a child. But Honorable Delhi High Court, again in this case, Pradeep Kumar versus State, observed that while considering the circumstances in which the alleged offense was committed, JJB has to consider the circumstances of the case in hand and not the involvement of CCL in other cases. So that means these FIRs or he being habitual offender, these might be relevant for deciding the bail application, but for conducting preliminary assessment, we are to see the circumstances of the case in hand and his involvement in other cases is immaterial. Now the third query is whether the provisions of section 19 are mandatory or is the Children Court merely to follow the recommendations of the board made under section 15 of the Act. So section 19 says that after the receipt of the preliminary assessment from board, CC may decide that there is need for trial of the child as an adult or as a child. Now this expression may has been explained by Honorable Delhi High Court in CCL LK alias LKP versus State. And it was observed by Honorable Delhi High Court that expression may used in section 19 does not give an option to the CC to decide or not to decide, meaning thereby to conduct preliminary assessment or not to conduct preliminary assessment, but the expression may decide is an option given to the CC to choose between two options, that whether he is to be tried as a child or as an adult. So that means it is obligatory on the part of the CC to take decision after receipt of the preliminary assessment report from the board. And this step cannot be skipped by CC. Now the next question is, what is the fate of the proceedings where no preliminary assessment is conducted by CC? Now what happened in this case? This preliminary assessment was conducted by JJB and the case was transferred to CC. But CC, instead of conducting fresh preliminary assessment, proceeded on to frame the charges, and a few witnesses were also recorded in this case. Then at the order regarding framing of the charge was challenged before Honorable Delhi High Court. And it was contended before Delhi High Court that proceedings stand vitiated because no preliminary assessment has been conducted and charge has been framed without following that procedure. But Honorable Delhi High Court held that it would not vitiate the proceedings thereafter undertaken by CC, but it would be an irregularity which can be cured. Now, how this irregularity can be cured? Firstly, Honorable Delhi High Court held that in both the eventualities, the trial, whether CCL was to be tried as an adult or as a child, the proceedings were to be continued before the children court. So that means there was no prejudice was going to be caused to the CCL. The only difference is to the procedure to be followed by the CC for trial. But it is mandatory for the children court to conduct the preliminary assessment. But another situation is, what is the fate of the proceedings where no PA is conducted by JJB and trial has commenced? Now, in this case, JJB, without conducting preliminary assessment, proceeded on to frame the charge and few witnesses were also recorded. Now, at that stage, it came to the notice of the JJB that preliminary assessment has not been conducted. Again, there is no direct judgment on this point, but after taking the guidance from the previous judgment, so we can say that it would not vitiate the proceedings thereafter undertaken, but it would be an irregularity. Now, how this irregularity can be cured? Now, if after conducting preliminary assessment, JJB comes to the conclusion that CCL is to be tried as a child, then no prejudice has been caused to the CCL because he has already been tried as a child. So that means JJB can proceed on with the trial after conducting preliminary assessment. But if after conducting preliminary assessment, JJB comes to the conclusion that he is to be tried as an adult, then the case has to be transferred to the CC for conducting fresh preliminary assessment and for the trial. And then CC will again decide that whether he is to be tried as a child or as an adult. But in both the eventualities, the trial is to be decided by CC. The only difference is that now CC cannot proceed on with the same charge or the notice framed or notice served upon the accused, upon the CCL, and charge has to be reframed and witnesses are to be recorded afresh by CC. So another situation is where trial has been disposed of by JJB without conducting preliminary assessment and issue is raised for the first time in the appeal. Again, there is no direct judgment on this point. Now, the situation is that preliminary assessment has not been conducted at all by the JJB and trial has been decided. Now this issue is raised for the first time in the appeal. Now appellate court can direct the JJB to conduct preliminary assessment and send the report without initially setting aside the judgment. Why? Because if JJB, after conducting the preliminary assessment, comes to the conclusion that he is to be tried as a child, then no prejudice has been caused to either party because CCL has already been tried as a child. And then the appellate court is to simply receive the report and to proceed further and decide the appeal on merits. But if the JJB, after conducting preliminary assessment, comes to the conclusion that the CCL is to be tried as an adult, then CC, Children Court, is left with no other option except to order the retrial after setting aside the judgment of acquittal or conviction, whatever. So in for this, I would like to refer to the case law of Isaac alias Kishore versus Ronald Cherian and others, 2018 RCR 9, page 925. In this case, Honorable Apex Court discussed the powers of appellate court under section 386 CRPC. So it was held that under section 386, power to direct retrial has been conferred upon the appellate court when it deals either with an appeal against judgment of conviction or of acquittal. So retrial, it was observed that retrial may be ordered when the original trial has not been satisfactory for particular reasons, like appropriate charge has not been framed, evidence wrongly rejected or admitted. So in the case in hand, also we can say in the case of juvenile, where no preliminary assessment has been conducted, that original trial has not been satisfactorily conducted. Because why? Because the mandatory provision of section 15 or section 19 has not been followed.
Screen पे आ गया.
It's to be seen that whether any prejudice has been caused to any party by not conducting the trial of child as an adult. So the answer in this case is yes, because victim is going to be prejudiced, as decision of JJB to try child as an adult eventually determines the punishment that can ultimately be imposed in case the said juvenile is found to be guilty. So another query is that, is there any scope of sending the matter back to JJB if CCL is not found fit to be tried as an adult in view of section 19(2)? And the connected query is that where appeal challenging finding of JJB under section 15 is accepted, whether the matter would be sent back to the board. So in the first situation, we can say that there is no dispute. I mean, there is no dispute regarding this because there is no scope of sending the matter back to JJB if CCL is not found fit to be tried as an adult in view of section 19, because the provisions of section 19 are quite clear on this. In both the eventualities, the CCL is to be tried by the children court. But the position we will discuss in the second is appeal challenging finding, where the appeal is pending before the JJB under section 15. Now what happens? The situation is where the children court has received the trial from the JJB after conducting the trial, and where JJB has found that he is to be tried as an adult. Now children court is having the trial before it for conducting fresh preliminary assessment under section 19, and on the other hand, appeal is also filed against the said order. So here rule 13 comes into play. It says, rule 13 sub rule 3 says that where an appeal has been filed, then CC shall first decide the appeal. So after deciding the appeal, where it is disposed of by CC that there is no need for trial as an adult, then CC shall dispose of the same as per section 19 of the Act and these rules. And just now we have seen that section 19 of the Act says that in both the eventualities, the case is to be tried by the CC itself. So we can say that even where appeal is filed, there is no scope of sending the matter back to the JJB once it is before the CC in either way, either by way of either receiving the case by way of transfer from the JJB, or either the matter is before the CC in an appeal. The next query is that as per explanation to section 15 of the Act, preliminary assessment is not a trial. Now, whether an opportunity to participate in the process be given to CCL. So here we have a case of PANNU versus CBI, criminal revision number 2366 of 2018 of our own Punjab and Haryana Honorable High Court. So in this case, what happened? The copies of the tests conducted by experts were not supplied to the CCL, but were shown just prior to the hearing of the case, just 30 minutes prior to the hearing of the case. And in this case, the counsel for CCL requested to cross-examine the expert, but no opportunity to cross-examine the psychologist or other expert was given to CCL in spite of his request. The Honorable High Court held that it was not practically possible to understand 35 pages of the report by any layman in a time period of less than 30 minutes. So CCL was not allowed to, it was observed that CCL was not allowed to cross-examine the experts to check the veracity of the reports in spite of specific requests leading to travesty of justice. So accordingly, the case was remanded back to the JJB to conduct fresh preliminary assessment after giving an opportunity to cross-examine the expert and after supplying copies to the CCL. So we can say that it does not mean that in each and every case the opportunity to cross-examine must be given, but it depends upon the facts and circumstances of each case. Because in this particular case, the circumstances were that some tests were applied on the juvenile, which were not found favorable with the court, or it was observed by the Honorable High Court that these tests were not fit to be done on the JJB. So that is why in that eventuality, Honorable High Court held that opportunity to cross-examine the expert must be given to the counsel. And it was further observed that copies of the test by medical experts to be provided to the CCL, parents and guardians before preliminary assessment along with other documents. And if need be, opportunity to cross-examine the psychologist or other experts must be given to CCL. Now the next query is whether omission to take assistance of psychologists or other expert vitiates the preliminary assessment. So the answer lies in this case, Ajay, son of one sword, but through versus the state of Maharashtra and another criminal revision application. So in this case, it was held that omission to take assistance of psychologists or other expert would not vitiate the preliminary assessment, because in the proviso itself it is mentioned that the board may or may not take the assistance of an expert. The last question is that where preliminary assessment is not completed within a period of 3 months, whether it would vitiate the preliminary assessment made thereafter by board. So in this very case, it was held that delay in preliminary assessment by itself would not vitiate the preliminary assessment made by the board, because there is no provision in the Act which mandates that in case preliminary assessment is not disposed of within 3 months as prescribed, it would not vitiate the preliminary assessment done at a later stage. But then it does not mean that we can exercise laxity in this. It has to be completed within 3 months, but if the circumstances are such that it is not possible for the JJB or for the children court or for any other reason, they're not able to complete this exercise of conducting preliminary assessment within 3 months, then it would not vitiate the preliminary assessment done at a later stage. And so this was about the third circumstance. Now we come to the parameters A and B, which we will discuss with the assistance of child specialist, child psychologist, Ms. AARZU Gupta. So she has already conducted preliminary assessment in more than 50 cases. So ma'am, first of all, we would like to know that how do psychologists, they assess the mental and physical capacity of the juvenile to commit heinous offense and ability to understand the consequences. I mean, is there any special test for the same, or the only test is IQ test?
Thank you, ma'am. I start the question for you first.
Question.
See, ma'am, IQ test is very important, and it is not only the IQ test. IQ test is one part of the preliminary assessment, because IQ test only rules out the intellectual disability. Intellectual disability is one condition where we can consistently say that the child at the time or even otherwise definitely lacks the capacity to understand the consequences of the action and does not have a decision-making ability and is vulnerable and can be used by anybody as a weapon to indulge into any kind of act, may offensive or non-offensive. In addition to IQ testing, we also carry out clinical interview where we try to understand, what is his frame of mind and how he generally reacts to situations in life, where we try to rule out if there is any psychopathology like depression, schizophrenia, anxiety disorder, or anything else, or substance and alcohol use that he may or may not be suffering from. Now, all these conditions that I have been saying, depression, anxiety, schizophrenia, this does not make the person incapable. The person very much has the decision making and the capacity to understand consequences intact. Other than if at the time of the offense, the child has been having active hallucinations or active delusions, which can be a symptom of either mood disorders or schizophrenia. But just having a history or a diagnosis of schizophrenia at some point in life does not make the child lose his capacity to make a judgment.
So, ma'am, how JJB and CC, they are supposed to read the reports and draw an inference from your reports, because we are layman to these reports.
Yes, ma'am. I will be talking that because that's primarily what I was told to cover in my PowerPoint. So there are 3 areas that I will be showing in the PowerPoint. So probably that will help and that will address. So reading the report. Now, whenever a report is submitted, usually, at least the medical report, the format that we follow from Government Medical College and Hospital. So I developed this format where we mention these 3 things. There will be a report, there will be demographics, there will be basic details about the age and about the FIR and police station and when we received the order from the Honorable Court. And after that, we always mention the IQ, intelligence quotient, which is a measure of intellectual capacity. Because as I said that IQ, the definition of IQ or the number of IQ rules out intellectual disability. So if any child has intellectual disability, definitely he lacks the capacity. So an IQ, you have to see the number has to be more than 70 or more than 70, because any score.
For treating him as an adult.
No, for treating him as an intellectually disabled.
Okay. Then it has to be more than
as 70. An adult and child is, ma'am, your domain. We cannot comment on that. Okay. So any number which is more than 70, which means his capacity to understand the consequences is perfectly all right. Okay. Anything which is less than this is defined as intellectual disability. So IQ more than 70, whenever you receive a report, it is usually categorized either he will be between 70 to 79, which means borderline intelligence, or it will be 80 to 89, which means dull average or below average intelligence, or his IQ will be 90, 92, up to 109, which means average intelligence. So definitely he has the capacity to understand the consequences. And of course, 110, 111, which at least in my experience,
more than is the maximum limit for 18-year child, below 18.
Ma'am, it is for all the ages. Okay. The number of IQ or the number 70, 75, 80, 85, this does not vary with the age. Okay. If as a child, the IQ is 85, even for a person of 20, 25, 30, 35 or 40, the IQ can be 85. And usually the intellectual capacity does not change as we grow older. So the functions change, cognitive functions get poor, attention concentration will be poor, the neuropsychological functioning changes with age, but the IQ does not change with age unless where we have received significant head injury cases in the hospital. So where, the CT scan or MRI show significant damage to certain areas of the brain. So where we again have a disability board in place. So then we can say that the brain areas have been damaged, and that can lead to deterioration of intelligence quotient or IQ score. But otherwise, for a normal person without any head injury or severe head accident, the IQ does not change, whatever IQ.
So that means if a juvenile who has committed heinous offense at the age of 17 years, but when produced before the psychologist has already attained majority, So that means it's possible for the psychologist to make an assessment of the mental capacity of the CCL had dating back at the age when he committed the offense?
Yes, ma'am, definitely. Because even if I, as a professional, if I'm making an assessment of a 24-year-old child in 2021, whereas the offense was committed either in 2015, 2014, 20. So if today in my assessment, he is coming and having an IQ before more than 70, there is no chance that he had intellectual deficit or intellectual disability in retrospectively. That's not possible.
So whether the psychological sciences can precisely identify the chronological age at which the capacity to commit a crime exists?
Yes, ma'am. If we see if we go by the theories of brain development or cognitive development, they say after 5 years, the brain is fully developed scientifically. The studies say by 5 years of age, because all the neural connections in the brain have been formed and established. After that, it's only enhancement of it, but the basic network has been. That is why even when we are assessing intelligence quotient or IQ of the patients, if I make an assessment at the age of 2 years or 3 years, I make an assessment, but I always tell the family that it has to be reassessed once the child has attained the age of 5 years. But any IQ assessment that has been carried at 5 or 7 years of age is usually applicable for rest of the life.
So that means you mention in your report the precise age?
Age of the juvenile, and that is rather one struggle sometimes when we face, because at times the age is not very well defined in the document when we receive. So it does not make a difference whenever I am making an assessment of child because scientifically they say the brain has developed by 16 years of age. 12 to 16 years of age is the last phase of cognitive development where we develop abstraction. Abstractability is the last to develop, and that is well formed from 12 to 16 years. So any juvenile who comes after 16, definitely we don't require the date of birth. Even if the date of birth is incorrect, it does not have any effect on IQ assessment. But if a juvenile comes at 14 years of age or even 15 years of age, where the date of birth or exact date of the birth is not known, definitely the IQ test findings become little unreliable. And we usually do mention when we face such a situation.
So how far the psychological science is reliable and accurate in assessing the mental capacity of a child?
As I said, ma'am, I would say to rule out intellectual disability, definitely. 100%. But when we talk about that, because I said there are other two things which also demand attention in the reading report, while reading the report, observation. So usually whenever we see, because we try to avoid using the word the child is trying to manipulate me during the assessment. So we use non-cooperative and oddities, sometimes if we see anything which is odd. So whenever you see such remarks in the behavioral observation, non-cooperative, defensive, guarded, because sometimes I know he knows he can respond very well to my questions or the test items, but he's trying to pretend that I am intellectually deteriorated, because they also very well know that if I don't respond at all to the question, the report will display that, maybe he has lesser IQ and he can escape.
So you come to know when he's pretending?
Yes, ma'am. And then we usually make this remark. So whenever anybody reads the report and in observation, you read these remarks, you become little vigilant that maybe this means that he has tried to manipulate the test administration, the setting.
So you have mentioned this under the heading of observation. Yes, overall BEH.
Overall behavior, like eye to eye contact and comprehension and response. Because when I'm conducting a test, I also have to see if my test finding and my general clinical observation, it matches. But sometimes we know the IQ test is coming lower, but though on clinical examination, he's sounding fine. I know clinically he doesn't appear to be intellectually disabled, but then why my test findings are giving me a score of 65? So if there is a discrepancy, we put that discrepancy. It happened in 2 cases. So where while submitting the report to JJ board, I even mentioned, and then, the reassessment was carried out. So sometimes then I had to request to send the juvenile to the hospital, because there I have a larger battery of tests which are available. So sometimes.
So in all the cases, you need the physical appearance?
Oh, yes, ma'am, definitely. It is always recommended. Otherwise, then again, the reliability on the test report becomes very lesser. It decreases the reliability.
At what age children are aware of their actions and their consequences?
Ma'am, now there is a concept of flying effect, which means after every decade, as we see probably the older generation, if I see my mother, grandmother, myself, and if I see the next generation, children and nieces and nephews, the generation is getting smarter.
Because of these.
Yes, ma'am. So that is why some of the tests also need to be revised, and you have to see what kind of tests need to be used. But otherwise, usually by 12, a person definitely starts to understand from 2015 the consequences of his or her action. That is what at least we believe in the psychology and theories.
And what about physical capacity? I mean, when do they have the physical capacity to commit a crime?
Ma'am, I would like to interject. I would like the psychologist to shed some light on the psychosocial maturity, because the test these tests.
Coming to that point also.
Please, thank you.
So when do they have the physical capacity to commit a crime?
When physical capacity is something I think I'm not the right person to comment, but otherwise now it depends what kind of physical strength you need. Otherwise, if you talk about the strength of bones and all that, of course, is orthopedic department, they conduct the.
So that means you need the facts of the case or circumstances before you can comment upon the physical capacity.
What exactly do you mean by physical capacity? Matlab, can I pick up this stone and
physical? Yes, physical capacity to commit the offense.
No, I think if
that is not
depend on the lifestyle. It is not primarily, as I said, I'm not.
Or the circumstances of the
case,
the kind
depend
of
on the lifestyle and how much physical strength. Some of us have more and some of us have lesser. So it will also depend what was the object that was used while committing the offense, and to what extent, what was retrospectively his lifestyle. If he's doing strenuous work and a lot of physical or labor work, then of course you can't question physical capacity in such a case.
As per Juvenile Justice Act, we have a Rule 10A, as per which board is to take the assistance of psychologists or other experts who have experience of working with children in difficult circumstances. So I just want to know that whether there are any specialist psychologists dealing with such kind of children.
And basically, when we talk about taking any other professional, by Rehabilitation Council of India, which is also an act, the clinical psychologist is the only professional who is qualified to conduct IQ test, intelligence quotient test, and understand the findings of or interpretation or norms of it. So anybody, when we say clinical psychologist, a lot of places earlier, not anymore, I guess, with the Mental Health Care Act of 2017 clearly defines that a clinical psychologist is the person who has MPhil in clinical psychology, not the university MPhil, which is a 1-year degree program, but a 2-year course recognized by Rehabilitation Council of India. So there are certain people, like even in my department, people of my qualification, there are 5 or 6 of us, but I have been working, in the field since 2012. So that experience definitely helps. But any person with this qualification can gain experience quickly. It's like, once you are a certain professional, you are qualified, but then tomorrow I may be picked up from here and, my head of department may put me into another field. I will gradually maybe use my all the knowledge and experience, but then we all have the capacity to journalize our knowledge and experience as well.
So, ma'am, what documents the experts need from JJB or CC while making an assessment? Do you need any?
Date of birth, ma'am.
Okay. So it is my request to all JJBs and CCs to send the date of birth of the CCL, whose medical examination or.
If you allow me to say this, okay. There are 2-3 points on this slide. Ma'am, first and foremost, date of birth, because if the juvenile is less than 16 years of age, though the preliminary assessment is not conducted for them, but in any other circumstances, then date of birth becomes mandatory. But for anybody who is 16 and above, for sure, we can manage without date of birth. And if
because only those children are sent to you who are between the age group of 16 to 18. But still you need the date of birth.
If it is there, it always becomes supplementary, because sometimes There also is confusion that, when they try to feign the documents and falsify the documents.
But that is for the board and CC to see. They send the children only when they are sure that they have attained.
But if
Yeah,
ma'am,
more than six-
I don't know, but is there any possibility that the juvenile is of 16 and a half, but 15 or 15 and a half? But that is not.
that is-
So in that case, we don't
So
need.
you don't need the FIR, you
No.
don't need the
No,
facts
ma'am,
of
we
the
don't.
case. You can come to the
We don't
conclusion
need
without
that.
going into the
No.
circumstances of the case.
Because that will also create a bias in a way.
Yes.
So I am only making an assessment of his mental health and mental capacity. So not knowing the background rather becomes more helpful, because then I'm submitting a very unbiased and a very reasonable report.
So what else you need from the
Identification, ma'am. Initially, we had this issue because at one point, Juvenile Justice Home had started sending the juvenile to the hospital. But then because there was no Aadhaar card and I didn't know if I'm making an assessment of this juvenile called Suraj.
Okay.
If this is Suraj who has come to me, or there is some imposter who is presenting himself as Suraj. So that was a difficulty for us. And then I requested them.
Because otherwise the confidentiality
Yes,
is to be
ma'am.
maintained.
Yes, ma'am. So then now I go to the juvenile observation home and make an assessment there, which is definitely more reliable, because there is no scope and no chance that somebody else can present to me, imposing that identity.
And you need the details of the FIR also, so that you
FIR,
can mention
it helps.
the same on the report.
It helps, ma'am, because sometimes there have been cases when I had 3 juveniles of the same name. So, just to avoid, when the board is reading the report, there is no confusion that this is which Suraj. Suppose there are 3 Suraj. So just to maintain that FIR number, having an FIR number, it helps in the identification. Basically, it's the same thing. Then I just wanted to say specialist, and of course, because a specialist is a qualified person to make a choice and the interpretation of test using behavioral observation and MSc mental status examination, which only a mental health professional can conduct. So any psychologist with a MA psychology or PhD psychology as well is not qualified to comment on observation and mental status examination, because that is something we are not trained. When I was MA psychology student, or when I completed, I was not trained. This kind of training of observation and MSc is something we get in our MPhil program. Even in PhD, you are not trained into all 3 aspects.
So we had one query from Mr. Sarah. Mr. Sarah, can you please repeat your question?
Yes, ma'am. I wanted the expert to shed some light on the psychosocial maturity, because according to her, the mental development take place by the age of this 16 years. But is the child between the age bracket of 16 to 18 years is able to assess the long-term consequences of his act? If she can shed some light on this psychosocial maturity of the.
Yes, sir. So when we talk about the maturity, see, sometimes, if all of us as humans, sometimes I may do something, I know the consequences, but I still just go ahead with it. कि ठीक है, चलो shortcut ले लेते हैं, there is a chance के tire puncture हो जाए गाड़ी का, but I have less time, I have to reach on this spot. Sometimes we all know the consequences, the road is bad. My tire may get flat, or there may be other problem, but we end up doing something. But this is something for very trivial things, where we keep taking risk. Again, people, as per the research and existing literature, people who get into juvenile delinquency, they have higher risk-taking capacity than anybody else. Also, for example, even when people invest in shares, stock, or other things, there is always a chance of losing. People do gamble, but there is always a chance of losing. So it's not that they are not aware. Every person who drinks alcohol, so many people, it's such a common behavior. You drink alcohol and maybe, okay, it's only one drink, so I can drive. So we know the consequences that by law, I should not be driving. It is not about, none of us do things which we know consequences are bad, but we all do certain things. But it is also about the intensity. Now, sometimes we even jump the red light. If my family member is hospitalized or if there is a call, if there is an urgency, I know I may be fined, it may cause, 10 or 20 minutes delay if I jump the red light. But sometimes people do jump red light because they know somebody else is dying in the hospital. So it is not about that I don't know the consequences of jumping the red light, but I still do.
But these are minor things, no?
Minor things, but
like murder,
I cannot,
offense of murder or offense of
exactly.
rape.
But I cannot slap my colleague because I know that is totally unprofessional, uncalled, and the consequences of such an act are going to be very severe. I will not, I will not disobey my authority because I know the consequences are going to be severe. So similarly, when you talk about having a judgment, it varies. I mean, even somebody who has a judgment may not sometimes take right action. But otherwise, cognitively, if you see scientifically, anybody who is 12 to 16 starts having a sense of judgment and consequences. Some children are more mature. It again depends. Some people who are very superiorly intelligent, they may have that maturity at 14 years. Or even 12 years, somebody who's like a genius. But somebody who's little lesser intelligent may develop it at 15 or 16. But anybody from 16 years and above, scientifically, the sense and the ability of making a judgment and understanding the consequences has been completely formed and developed. But how you use that ability of judgment is your choice, which is dependent on your the kind of family background you come from, the kind of designation or post you hold. For example, even when we see extramaritals in our psychosexual clinic, of course everybody knows the consequences. We have couples where they know the consequences, but people still indulge into it.
Ma'am, may I add further, ma'am, like in case of juveniles, especially between the age bracket of 16 to 18 years, now their traits are not well formed. They have signature, we can say, traits like risk-taking capacity, impetuosity, impulsivity. So question is, what are the chances of reformation in their cases, because all these signature traits, they wither away with the passage of time as they grow. So before the board and before the children court, one of the key assessment in such situations are not only to find out whether this child should be tried as an adult, which will definitely expose him to a harsher punishment once he is removed from the board and is put before the children court and tried as an adult, then he definitely faces the risk of spending the maybe next 20 years in jail. So question is, by assessing the psychosocial maturity in case of juveniles between the age bracket of 16 to 18 years, can the psychologist or the expert can help the board or the children court while making their assessment in these inquiries?
Okay. So during the assessment that we conduct, we try to understand from two perspectives. One is cognitively. As I said, by 16, his cognitive development is definitely completely formed. But each of us is different. A 16-year-old can think of, plan to be a pilot. A 16-year-old can plan to be a doctor or engineer or a lawyer or have a successful career. Or a 16-year-old can even have a plan कि right now it's too early, मैंने तो कुछ सोचा नहीं है, कल जब होगा तब देखेंगे, पहले कॉलेज खत्म कर ली. So the planning and organization, everybody has the capacity, but not necessarily they use it. So we try to understand his thinking and his decision making, day-to-day decision making. मतलब sometimes the juvenile say कि हाँ मैं काम करता हूँ, मैं 6,000 रुपए कमाता हूँ. So try to understand कि तुम उस 6,000 का करते कैसे हो? How do you utilize that 6,000 money? Second and most important is character. How the juvenile usually responds to the situation. फ्रेंड ने थप्पड़ मारा, फ्रेंड से लड़ाई होगी तो ऐसे में क्या करोगे? स्कूल में टीचर ने डांट दिया, ऐसे कैसे डांट दिया टीचर ने? मैं तो उसके बाद स्कूल ही नहीं किया, मैंने टीचर को धमका दिया. So that also reflects his character, which is formed longitudinally since childhood. His impulse control. Yes, you are very much right when you say that teenagers, especially the young adolescents, are very aggressive. We all say it's a very turmoilish age and there's a lot of aggression and impulsivity for that age. But we also try to see whether the child has been deviant and obedient in childhood. Because if we understand teenagers are usually aggressive, we also understand that in school age, every child has to follow the discipline and obey the teacher and show respect to teachers and show respect to other elders, at least till 10 and 12 years of age. So to understand these two aspects of cognition and character, if you understand juvenile delinquency, there are some precursors. Precursors means there are some risk factors or red flags which can be identified going back to the childhood history or the personal history of the juvenile. If in the childhood he displays behaviors which are defined, where he has never been respectful to authority, he has never followed the do's and do nots, that is evident, and there has been conduct disorder, he has been lying, because a child of 8 to 12 years, if he gets into lying, disappearing from home without permission, there are about 22 symptoms of conduct disorder. So we try to make an assessment. And of course, juvenile delinquents, I'm so sorry, I can't give you the exact percentage, but it is very well reported. They grow into antisocial personality disorders. And antisocial personality disordered people are usually, these are the features, they don't regard the rules, norms, and obligations in relationships and in society. They have low frustration tolerance. So even if somebody has hit me, I may even murder that person just because he slapped me. I feel so humiliated. I can't tolerate and let go. They have no sense of guilt or remorse. They usually blame for their actions. मैंने उसने जी मैडम मर्डर तो इसलिए हो गया, उसने मेरे को मारा, अगर उसने मारा ना होता तो मैं क्यों हाथ उठाता. So they have all these rationalizations for their actions which fall beyond remorse or guilt. So we also look for childhood discipline, authority, how he has been reacting to rules and authority, what are the do's and do nots, whether he has been compliant. So if he has been otherwise compliant and obedient, he respects rules and his law-abiding behavior, he has some future goals. So that means, okay, mostly his sense of judgment, not sense of judgment, but this reflects his character, emotional and impulse regulation. So I know I have not exactly answered the question, but I hope this helped you to understand what I'm trying to say.
Ma'am, do you want to add something else on this?
Just this slide, ma'am, if you permit. So when we see an individual, the kind of choices or decisions he makes, whether I have to take a risk or I don't have to take a risk, all of this also depends on the genetic loading, because whatever we are, there are things which make human. Genetic loading, if the father has a temperament or antisocial personality traits, or father or mother, either of them, then there is a high possibility that the child will display antisocial or conduct disorder such traits. If the father or mother, if any of the parent or even grandparent on either side has impulsivity and high risk, suppose the father is into gambling, there are higher chances that the juvenile or any child would display such traits. And of course, environment, where we try to, that is why if you see the social background report and social investigation report, that throws a lot of information and light on the kind of family environment the child has been raised, on the peers, the kind of peers. Sometimes you have juvenile who have dropped out of the school from class 4. You know, a child is usually 8 or 9 years old when he's in class 4th or 5th. From 10 to 16, 10 to 14, he was doing nothing but just roaming in the streets. So we can imagine the kind of peers he would have been interacting with. And of course, by 14, he got into a dhaba or some job. And there starts the delinquent acts, finally one day, which brings him to land into juvenile in front of juvenile board. Of course, we also need to understand society, but this I'm talking from a mental health professional perspective. So this is what I try to look into when I am making an observation, even to comment on these three things.
Ma'am, I can put this last question
Yes.
as an expert, because the children which come before us are in difficult circumstances. They come from the very marginalized section of the society. Most of them are illiterates. They have got difficult childhood, broken homes. So while making the assessment at your end, do you take all these social factors which have turned them into such a personality or a character that where they're not able to assess properly about their actions and all that? Are all these factors, do you take these into consideration?
Sir, as part of the medical board, my job is to comment only on these three things since 2016. But yes, earlier when I got associated with these three things is what presently I have been commenting since 2016. But initially when I was introduced to juvenile board in 2012 by my head of department, definitely I developed a performer there viewing all of this slide and this slide. So all these factors, and that is now the CCPCR, the DCPUs, the performers that they conduct. So all that information, all this information is there so that the juvenile board, probably, it's my assumption, is more educated and learned about the background factors, which definitely helps the final authority to understand the circumstances under better light.
That means, ma'am, it's not, the report is not definitive, it is opinionative. The report of the expert. No, we can say that. And
no, ma'am, on these things it is definitive, ma'am. On these things it is definitive. There is no opinion. IQ is a definite thing. Observation is not definitive because it is for that moment. So maybe he's trying to manipulate me, but he may be very genuine in front of you. And of course, mental status examination is again not definitive. It is for that moment. He may have displayed depression 6 months back, but today maybe he now remitted, means in a state where there is no symptom of depression.
So in nutshell, we can say that the formulation of the opinion must be by the board, and the board cannot abdicate its essential judicial functions. And the main consideration should be the circumstances in which the alleged offence was committed. And if the board is not able to make out from the fact to the circumstances of the case regarding the state of mind of the child, then the board can definitely take the opinion of the expert. So this was all about the preliminary assessment. So thank you very much. Thank you, ma'am.
Ma'am, there was one thing which was asked, that is there any way that when Juvenile Justice Board or the authorities do not have a psychology person available, if they can try to understand what assessment to make?
Can they make?
They can. So if you can just give me, I'm sorry, I know I'm bypassing 5 minutes. I can.
It's all right, ma'am.
Yes, so sometimes there may be situations because as there are only about 7-8 districts in Punjab out of all 23 districts which do have a clinical psychologist. So I'm sure there must be a lot of situation and times when you don't have a clinical psychology expert who can carry out the assessment to rule out intellectual disability. So you may not be able to rule out other psychopathology, but intellectual disability a lot of times can be, at least some fair amount of it can be assessed. There are 3 usual things that we do: general awareness and knowledge of the child, adaptive functioning, and IQ testing. Now, IQ testing falls in the domain of an expert, but because I was requested that if you can just throw light. So as a non-specialist, any of you can just talk to the child, or even you can, tell or delegate this to your juniors. So when they talk to the child, सिंपल क्वेश्चन मैं हिंदी में बताऊं, आप क्या करते हैं, आपके परिवार में कौन है, मम्मी की उम्र कितनी है, मम्मी कितना पढ़ी है, पापा की उम्र कितनी है, पापा कितने पढ़े हैं, भाई बहन कब है, आपका जन्म कब हुआ? अगर वो कहता है 2000 में, अच्छा छोटी बहन का जन्म कौन से साल में हुआ, उससे छोटी का कौन से साल में, वो कौन सी कक्षा में पढ़ती है, दूसरे कौन सी कक्षा में पढ़ते हैं, बहन का जन्मदिन कब होता है, बहन पढ़ाई में क्या करती है, अगर आप एक ही स्कूल में है तो आप बहन की क्लास में जाते हो क्या? तो थोड़ा सा फैमिली के बारे में उनकी अगर फैक्चुअल इंफॉर्मेशन लेंगे, डेट ऑफ बर्थ एंड ऑल, इंटेलेक्चुअल डिसेबिलिटी वाले बच्चे के लिए वो बताना मुश्किल हो जाता है. आप कहाँ से आए हैं, अगर बोलता है मैं मलोया से आया हूँ, अच्छा मलोया यहाँ से कितने किलोमीटर दूर है, मलोया से आप यहाँ कहाँ कैसे आए हैं, अगर वो बोलता है साइकिल से आए, कितना समय लग गया. सो द ओरिएंटेशन एंड स्पेस टाइम सेंस, द किलोमीटर, द डिस्टेंस सेंस, वो यूजुअली इंटेलेक्चुअल डिसेबल्ड बच्चों में बहुत अच्छी नहीं होती. स्कूल एंड एकेडमिक्स में, स्कूल में आप कितने, मैंने 6वीं तक पढ़ा है, उसके बाद स्कूल छोड़ दिया. 6वीं तक अगर पढ़ा है तो क्या होता है, अच्छा मुझे बताओ 2 का पहाड़ा सुना दो, टेबल सुना दो 2 का. अगर वो 2 का सुना देता है तो मैं थोड़ा डिफिकल्ट पूछूंगी 7 का या 11 का या 12 का. तो सिंपल एडिशन, अगर आपके पास मान लो 100 रुपए हैं, आपने ब्रेड खरीदी जो कि 10 रुपए की आ गई, फिर आपने बटर खरीदा जो कि 42 रुपए का आ गया. अब मुझे ये बताओ कि दुकान से आपको कितने पैसे वापस मिलेंगे. तो थोड़ा सा एडिशन, सब्ट्रैक्शन, मल्टीप्लिकेशन आप अगर पूछें, यूजुअली अ चाइल्ड विद अ इंटेलेक्चुअल डिसेबिलिटी कैन नॉट डू दिस मेंटल मैथ्स। ऑक्यूपेशन पूछ सकते हो, अच्छा वो जब वो कहता है कि मैंने 6वीं में पढ़ाई छोड़कर फिर मैंने तो जी ढाबे पे लग गया था या होटल में लग गया था, कितने पैसे मिलते थे? 5,000 मिलते। सो देन आई आस्क हिम हाउ ही मैनेज मनी। 5,000 में से क्या करते हो? 3,000 मम्मी को दे देता था, 2,000 का क्या लेते थे? पैंट कमीज खरीद देता था, कितने की? 300 रुपए की। अगर मैं देख रही हूँ कि वो 2,000 का मुझे समेशन सा दे देता है, सो अगेन अ चाइल्ड विद इंटेलेक्चुअल डिसेबिलिटी will not be able to do जनरल अपडेट अवेयरनेस। फिर आजकल इलेक्शन है तो जो भी करंट अफेयर हो थोड़ा उसका पूछ लो, इर्द गिर्द का पूछ लो। तो इस सब बातचीत में एंड में यू विल हैव अ फेयर जजमेंट ऑफ हिज कॉम्प्रिहेंशन एंड स्पीच प्रोडक्शन। अगर आपको लगता है कि ठीक सवाल ठीक इस्तेमाल है, you will be in a very good space to identify, to rule out intellectual disability.
So that means JJB and CC, they can also check the mental capacity of the CCL at their own level by asking
intellectual disability, ma'am,
and
not mental capacity.
Okay, I'm sorry, intellectual capacity at their own, and by asking these simple questions.
If we can give a very fair, when you sometimes there are situations.
Thank you, ma'am, for
enlightening
us on this topic. Thank you so much.